distinguished guests, ladies and gentlemen. Good evening, and thank you very much for joining us tonight for the third annual Supreme Court ADR address, sponsored by the Australian Disputes Centre. My name is John Wakefield, and I'm Chair of the ADC. In welcoming everyone this evening, may I first acknowledge the Aboriginal and Torres Strait Islander peoples, and as traditional custodians of this land, the Gadigal people of the Eora Nation. I pay my respects to their elders past, present and emerging. We're very grateful to the Chief Justice for making the Banco Court available for this lecture. We're also grateful to those involved in operational matters who have ensured that this event can take place both in person and remotely, with around 200 people registered. The vision which the Court showed in introducing court-directed mediation in the 1990s has long since proven its efficacy in resolving large numbers of litigated matters prior to hearing. The innovation was also a watershed in advancing the community's acceptance and use of alternative dispute resolution processes across sectors of civil society. As we all know, many people today seek to resolve their disputes themselves before or during litigation. They use a variety of ADR processes, including mediation, expert determination and arbitration. Although expressed to be in the alternative, ADR has in fact become mainstream. Not only do courts and practitioners require or anticipate the use of ADR processes, clients have now come to expect them. Society demands access to justice, and a successful relationship between the courts and the ADR industry contributes extensively to reducing the personal, financial and public costs of litigation. The Australian Disputes Centre has a long association with the Supreme Court of New South Wales. It stretches back to the ADC's establishment in January 1986, when then recently retired Chief Justice Lawrence Street conducted ADC's first mediation training. As a facility, the Australian Disputes Centre operates in a number of respects. It conducts mediation training to the National Accreditation Standard. It provides hearing rooms, meeting rooms and breakout rooms for the conduct of arbitration and mediation. It provides case management and logistic and support services. Lastly, in collaboration with the Australian Centre for International Commercial Arbitration and the Australian branch of the Chartered Institute of Arbitrators, it provides a focal point for ADR support, development and practice. We're very pleased tonight to have as our guest speaker the Honourable Justice Andrew Bell, the President of the New South Wales Court of Appeal. Justice Bell graduated from the University of Sydney with first-class honours in both arts and law. He was awarded the University Medal in each degree and was also awarded the Sydney University Convocation Medal. His Honour was Rhodes Scholar for New South Wales in 1990. He graduated with first-class honours and was awarded the Vinerian Scholarship for first place in the Bachelor of Civil Law at Oxford University in 1993. His Honour completed his doctorate in 1994. His thesis formed the basis for his subsequent publication, Forum Shopping and Venue in Transnational Litigation. His Honour was admitted to the Bar in New South Wales in 1995 and was appointed Senior Counsel in 2006. His Honour had a broad national practice at trial and appellate levels and appeared in 30 appeals in the High Court of Australia. He also had an extensive international arbitration practice, conducting arbitrations in London, Singapore, San Francisco, Melbourne, Sydney and Perth. Since 2008, His Honour has been Adjunct Professor at Sydney University Law School, where he teaches private international law. He is co-author of NI's Conflict of Laws in Australia. In 2012, His Honour was named a Fellow of the Australian Academy of Law. In 2019, His Honour was appointed the President of the New South Wales Court of Appeal. His Honour's topic tonight is the rise of the Anti-Arbitration Injunction. Would you please join me in welcoming Justice Bell to the lectern?
Thank you very much, John. By and large, and perhaps overwhelmingly, arbitration has had a very good run with common law courts, including Australian courts. By that I mean that in numerous areas, common law courts have promoted the importance of arbitration and supported key aspects of the framework of the New York Convention and the Insutra Model Law in a way that has made the arbitration of commercial disputes the preferred mode of dispute resolution throughout the global commercial community. Tangible ways in which contemporary judicial support for arbitration can be seen may be readily enumerated and include, first, the embrace of the competens principle, that is to say, the ability and entitlement of the arbitral tribunal to consider and rule on its own jurisdiction. This is, of course, explicitly recognised in the model law, but it is reinforced by the willingness of courts of many countries to refer matters to arbitration even where the existence or enforceability of the arbitration agreement is in issue, leaving jurisdictional disputes for determination in the first instance to the arbitral tribunal. This was a principal aspect and focus of the decision of the full court of the Federal Court in Hancock, Prospecting and Reinhardt. The second obvious illustration of judicial support for arbitration may be seen in the adoption of a very generous approach to construction as to the scope of arbitration clauses associated in Australia with Francis Travel in this court, Commandant Marine in the full court of the Federal Court, and in the subsequent Hancock decisions both in this court and in the Federal Court, although with a nuanced difference between those two courts, and the same trend illustrated in England in Fiona Trust. Thirdly, the very broad and perhaps somewhat controversial interpretation given to the concept of through and under by a majority of the High Court in the Reinhardt litigation, an interpretation that in my opinion will be likely to generate many more disputes as to who is bound by an arbitration agreement, or more accurately, an award consequent upon such an agreement. But the broad interpretation is consistent with the judicial support for the reach and efficacy of arbitration. Fourthly, the expansion of the concept of arbitrability, that is to say, the subject areas that are capable of settlement by arbitration. Fifthly, judicial restraint in the scrutiny of the quality of the reasoning process in arbitral awards. Sixthly, adoption of a relatively circumscribed view as to arbitral misconduct, adequacy of notice and bias. Seventhly, the narrow view as to when considerations of public policy will preclude enforcement of an award. And lastly, but certainly not least, the willingness by anti-suit injunction to restrain parties from pursuing court proceedings commenced abroad in circumstances where the moving party in such proceedings is party to an arbitration agreement. Although principally on the basis of breach of contract, examples can also be given in England of so-called quasi-contractual anti-suit injunctions being granted to restrain non-parties to arbitration proceedings from bringing foreign proceedings as if they were party to an arbitration agreement, another variation of the broad view of through and under. In the quarter century since the English Court of Appeal delivered its famous decision in the Angelic Grace, anti-suit injunctions have been one very important and robust way in which common law courts have supported the arbitration process. Indeed, even where there may be an issue as to the existence or currency of an arbitration agreement, or a question as to the parties thereto, there need only be a high degree of probability on the authorities that there is an arbitration agreement for an anti-suit injunction to issue and restrain foreign proceedings brought in the face of it. This robustness of approach has only been reinforced by the United Kingdom Supreme Court's decision last Friday in Enka Insat. Anti-suit injunctions in this context are based upon the promise implicit in the fact of the arbitration agreement not to bring proceedings in court in a manner inconsistent with the agreement to arbitrate. An arbitration agreement will typically be construed as involving a promise exclusively to resolve disputes by arbitration. This is the, quote, often silent concomitant or, quote, negative aspect of an arbitration agreement referred to by Lord Mance in the Ust-Kamenogorsk case in the UK Supreme Court. The robust approach of common law courts, of course, by means of anti-suit injunction to enforce arbitration agreements, famously hit a roadblock with the European Court of Justice's decision in West Tankers, insofar as court proceedings commenced in Europe in the face of a London arbitration clause were concerned. The European Court held that the ground of anti-suit injunctions was inconsistent with the scheme for the allocation and exercise of jurisdiction under the European regulation. Post-Brexit, the West Tankers roadblock is one which one might have thought unlikely to remain in place, but this will ultimately depend upon the extent to which the United Kingdom continues with a parallel but mirror set of jurisdictional arrangements vis-à-vis the European Union. That's a parallel set of arrangements to those contained in the so-called recast Brussels regulation, which came into effect after the Brexit process was first announced. Now, my lecture tonight is not on anti-suit injunctions, but on anti-arbitration injunctions. Notwithstanding the similarity in the nomenclature, those two creatures could not be described as siblings. Distant cousins may even be a stretch. They have some features in common, but in many respects they serve entirely different purposes. When deployed in the context of an arbitration agreement, the anti-suit injunction reinforces the contractual promise to arbitrate, whilst the anti-arbitration injunction, on the other hand, seeks to bring an actual or threatened arbitration to a temporary or permanent halt. As such, anti-arbitration injunctions very much go against the broad trend of judicial support for arbitration I've already referred to. And one striking difference between the anti-suit injunction and the anti-arbitration injunction is this, that whereas the former anti-suit injunctions have their antecedents in the common injunction of the English Court of Chancery, anti-arbitration injunctions have on occasionally been issued by civilian courts. Now, I pause here to interpolate by way of general observation that there can, of course, be ebbs and flows over time in the law, generally, and in the law's attitude to, enthusiasm and support for particular arrangements and practices or principles. Respect for freedom of contract and party autonomy supplies a good example. At one point in time, the age of Lord Justice Scrutton and famous decisions such as the Strange and Graucob, freedom of contract enjoyed primacy, and holding of people to their bargains, including in respect of exclusion clauses, was of paramount value. But a combination of judge-made and statute law has tempered that position as doctrines of unconscionability, the expansion of estoppel, and the emergence of good faith all gain momentum in the face of a recognition that injustice may result from too rigid and inflexible a respect for freedom of contract. The rise of the anti-arbitration injunction, my topic for tonight's lecture, may not represent a turning of the tide in judicial support for arbitration of the same kind or dimension as the retreat from freedom of contract, but the remedy is a tool by which broad judicial support for arbitration may be moderated and arbitration to a degree controlled. The enthusiastic embrace of arbitration by common law courts in the various ways already outlined is not necessarily immutable or all one way. The degree of support may vary if the model of arbitration shows itself to be flawed or corrupted, or if concerns arise as to the integrity or efficacy of the arbitral process. One area of contemporary concern, the increasingly perceived scope for conflicts of interest by arbitrators, was the subject of the corresponding lecture delivered last year by Her Excellency, the Governor Margaret Beazley. There is an obvious tension between broad contemporary judicial support for commercial arbitration, including and perhaps especially international commercial arbitration, on the one hand, and the very existence of a remedy that entails restraining a party from triggering or continuing an already commenced arbitral proceeding, or perhaps even, and more radically, restraining an arbitrator, him or herself, from continuing to conduct the arbitration. This tension is reflected in the title of Professor Richard Garnett's recent article in Arbitration International, quote, Anti-Arbitration Injunctions, Walking the Tightrope, which, as with all of Professor Garnett's work, is a most valuable contribution to the secondary literature. Later in this lecture, I will consider the theoretical cases for and against the grant of our anti-arbitration injunctions. But as my title suggests, whatever the merits of the arguments against the use of this remedy, it is clear that there has been a rise in the number of cases where anti-arbitration injunctions have been granted in recent years, and in many different jurisdictions around the world. Instances can be cited from the United Kingdom, the United States, Canada, Australia, Malaysia, India, Pakistan, Bangladesh, Brazil, Ethiopia, and Indonesia. And there is a growing body of secondary literature in this field. The anti-arbitration injunction, though not necessarily known by that name, is not a wholly modern phenomenon. The well-known decision of the House of Lords in Bremer-Vulcan is now 40 years old. In the same year as Bremer-Vulcan, the United States District Court of Appeals for the First Circuit, in an opinion delivered by then Circuit Judge Stephen Breyer in the first of now 40 years on the bench, said, and I quote, "To allow a federal court to enjoin an arbitration proceeding which is not called for by the contract interferes with neither the letter nor the spirit of this law," referring to the federal arbitration law. Rather, he said, to enjoin a party from arbitrating where an agreement to arbitrate is absent is the concomitant of the power to compel arbitration where it is present. The United States Federal Arbitration Act expressly contemplates in section 16.2 an appeal from, quote, an interlocutory order granting, continuing or modifying an injunction against an arbitration that is subject to its title. In other words, the very notion of an anti-arbitration is built into the text of that very important statute. Now, I said there has been a rise, but you'll be surprised at the extent and the level of the rise in recent decisions. Let me give some examples. First with Australia, in the 2018 decision of Justice O'Callaghan in the Federal Court in a case called Kraft Foods and Bega Cheese. This was the beginning of what have become colloquially known as the peanut butter wars, largely an intellectual property dispute. But in this particular instance of it, an early instance, His Honour Justice O'Callaghan granted an anti-arbitration injunction preventing Kraft from proceeding with a New York arbitration pending the determination of proceedings on foot in the federal court between the same parties. And notwithstanding the fact that the dispute, the subject of arbitration, was held to fall within the arbitration clause. The subject matter of the arbitration and the court proceedings had considerable overlap and together was said to pose a real risk of inconsistent findings. The court issued the injunction relying on its implied power to protect its processes once set in motion in circumstances where, although the dispute, the subject of the New York arbitration, as I say, was within the scope of the clause, Kraft had brought a cross-claim in separate federal court proceedings. Significantly, the anti-arbitration injunction was issued notwithstanding a finding that Kraft had not waived its right to arbitrate by bringing the proceedings. Next is a 2019 decision of the British Columbia Court of Appeal in a case called Lee and Rao, in which the moving party in a CTAC arbitration was temporarily restrained pending the determination of certain questions between the same parties in proceedings in the Supreme Court of British Columbia, in circumstances where the court found that those parties had agreed that one issue between them would be resolved in court proceedings prior to any arbitration, and that the contractual promise, in effect, not to arbitrate until the question had been resolved in judicial proceedings, was breached by the party restrained from pressing on with the arbitration. Then there is the 2019 decision of the Federal Court of Malaysia, the ultimate appellate court of that country, in a case called Jaya Sudhir, in which an anti-arbitration injunction was granted on the application of a non-party to the arbitration agreement, restraining Malaysian arbitration proceedings in favour of litigation in the Malaysian courts in order to prevent the non-party from being left without any meaningful remedy. This is a wide-ranging and important decision of an ultimate appellate court which, interestingly, cited Justice O'Callaghan's decision in Kraft, as well as Justice Alsop, as he then was, 2004 decision in a case called Incitec and Alchemos, as to the importance of all aspects of a dispute being resolved in one forum, a goal which, as we all know, inter partes arbitration will often be unable to deliver. The decision also sets out limited circumstances where a third party may successfully and somewhat counterintuitively sue to restrain the continuation of arbitration proceedings to which that party is not privy. The next decision, also from 2019, so you get the flavour of the currency of this topic, is the decision of the Court of Appeal of England and Wales in a case called Sabag and Khoury, in which a Lebanese arbitration was restrained on the application of a party who had been joined in those proceedings but who had earlier obtained a ruling from the English courts that she was not bound by an arbitration agreement contained in the family company's Articles of Association. Then there was a further decision of the English Court of Appeal in 2019 in a case called Ministry of Finance and One Malaysia Development, Berhad, a case arising out of the alleged notorious corruption said to involve the former Prime Minister of Malaysia, in which there was pending a review by the English courts under Section 67 and 68 of the UK, the 1996 Arbitration Act, of a consent arbitration award, and a subsequent arbitration had been initiated pursuant to an arbitration clause contained in the deed of settlement which gave rise to the consent award. There was an issue as to whether the consent award had been obtained fraudulently, secured fraudulently, and in the deed of settlement there was also an arbitration clause. The English court refused effectively to enforce that and restrained an arbitration pursuant to that second clause pending its review under the UK legislation of the original consent award. Also in 2019, the American Law Institute issued its proposed final draft of the restatement of the US law of international commercial investor state arbitration, with the acclaimed Professor George Berman of Columbia Law School as reporter. That final draft, the product, as with all restatements, of deep discussion and national survey, accepted the ability of United States courts to issue anti-arbitration injunctions in a variety of circumstances, and explicitly rejected the view that their issue is inconsistent with the global architecture of international commercial dispute resolution represented by the model law and the New York Convention. And in the context of the United States, I might also draw attention to a decision of 2015 of Judge Kaplan, the judge famously associated with the Lehman Brothers liquidation, who restrained an aspect of dispute going to arbitration. In the course of his judgment, he said, much as Justice Breyer had said many years before in the decision I earlier referred to, that arbitration of a particular grievance will not be ordered where it may be said with positive assurance that the arbitration clause is not susceptible of an interpretation that covers the asserted dispute. And the converse of that position, in other words, a clear finding that an arbitration clause is not applicable for one of the very many various reasons, waiver, construction, scope, etc., will, in the United States, it would seem, justify and warrant the grant of an anti-arbitration injunction, let's say an injunction restraining a proceeding which, if ex hypothesi, has no contractual basis or has been found to have no contractual basis. Now, functional equivalence of the anti-arbitration injunction may also be noted. Thus, in a recent decision of the New South Wales Court of Appeal, a case called Ingham's Enterprises and Hannigan, the majority declared that a particular dispute, which had been foreshadowed in a notice of dispute, fell outside the scope of the arbitration clause. No point was taken that this question should have been left to the yet-to-be-appointed arbitrators to decide. Whilst an injunction was not in terms sought, one would no doubt have been granted had the unsuccessful party sought to pursue arbitration following the court's declaration as to the scope of the arbitration clause and that the dispute in question fell outside that scope. A second functional equivalent is supplied by the decision of the full court of the Federal Court in Haifert and Quekang Maritime Carriers No. 5, a decision of about just over 20 years ago, a rare Australian case reported in the Lloyd's reports. Although a stay of an aspect of proceedings which fell within the scope of an arbitration was ordered in that case, and that aspect was consistent with the Section 7 of the International Arbitration Act referred to arbitration, the court used its power to impose conditions under Section 7.5 of the International Arbitration Act, arguably controversially, to make the following order, and I quote, "The claims brought by the plaintiffs against Western Bulk Carriers for breach of the charter contract and the related claims in negligence would be stayed," so far perfectly orthodox, "on condition that the reference to arbitration in respect of those claims not proceed until after the final determination of the proceedings in the federal court." In other words, there were multi-party proceedings in the federal court. Two of the parties were bound by an arbitration agreement, but there were other claims, all arising out of the same factual circumstances. The court did, as it was obliged to, stay that aspect which was the subject of the parties bound by the clause and which fell within the scope of their dispute, but effectively restrained that arbitration from occurring until the court had resolved the balance of the proceedings before it. To all intents and purposes, an interim anti-arbitration injunction. Now, it should not be thought that the trend in favour of the issue of anti-arbitration injunctions, to which I've referred, is all one way. Also, in 2019, August 2019, the Supreme Court of India, in a decision called National Aluminium and Subhash Engineers, has held, following an earlier decision in Kvaina Cementation, India, reported in 2012 but delivered 11 years earlier, that an anti-arbitration injunction should not lie where one party disputed that a condition necessary to the existence of the arbitration agreement was unfulfilled, and it held that this question should be determined by the arbitrators. Kavena, the earlier decision, had not been referred to in a 2016 decision of the Division Bench of the High Court of Delhi in a case called McDonald's and Bakshi, a decision which gained quite a lot of international attention at the time it was delivered, and accepted that the jurisdiction to issue an anti-arbitration injunction existed, although it was not exercised in that case. But in the High Court of Delhi in March of this year, in a case called Modi and Modi, the rather curiously named Mr. Justice Endlaw expressed the view that the Indian Arbitration and Conciliation Act of 1996 was a complete code in itself, and that, quote, courts cannot interfere with the code pertaining to arbitration laid down in the statute by exercising jurisdiction to do so, for which equally efficacious relief can certainly be obtained before the arbitration tribunal. In other words, the architecture of arbitration, the statutory architecture of arbitration precluded an anti-arbitration injunction in circumstances where a challenge to the arbitrator's jurisdiction could be entertained by the arbitrators under the competence principle. Now, I pause here to note that in two very recent Australian decisions in the context of the State Commercial Arbitration Acts implementing the model law domestically, Section 5, which provides that, quote, no court must intervene except where so provided by this Act, has been interpreted by the Chief Justice of Western Australia as a code, and therefore to exclude any general or residual powers given to the domestic court which are not specified in the Act. And there is, of course, no power in the Act to grant an anti-arbitration injunction. That's another case in the Hancock litigation, Hancock Prospecting and DFD Roads Pty Limited, an aspect, I think, of the dispute with the Wright family. And that decision has very recently been followed in Victoria by Justice Lyons in a case called Transurban and CPB Contractors. Now, in the latter case, Justice Lyons observed that as a consequence, let's say a consequence of a conclusion that Section 5 operates as a code, this would appear to include a removal of the court's inherent or auxiliary equitable jurisdictions, which is a large statement, including the power to issue anti-arbitration injunctions. Justice Lyons did, however, go on to hold that where there are two related arbitrations on foot, the court would have the power under Section 17J of the Commercial Arbitration Act, interim relief, to restrain for a period one arbitral process while a related arbitral process was in progress. So it's not wholly inconsistent with the grant of anti-arbitration injunctions, but only in that very unusual situation where there were two arbitrations on foot. Now, it should be noted that many courts which have asserted the jurisdiction to issue anti-arbitration injunctions have simultaneously asserted that they should only be issued in exceptional circumstances, although it may be noted that Justice O'Callaghan did not accept such a limitation in the Kraft litigation. One feature of some of the recent decisions that I've referred to, including Kraft, is that the court issuing the anti-arbitration injunction was not a court of the seat of the arbitration. It's usually, of course, as everybody knows, the court of the seat of the arbitration which plays the principal role in the supervision of the arbitration. And this is an issue to which I shall return. But what is noteworthy is the significant amount of international judicial attention paid to the subject of anti-arbitration injunctions in the last 12 to 18 months, and attention at senior appellate, intermediate and ultimate appellate levels. I turn now to consider the bases for the grant of anti-arbitration injunctions, and the recent examples I've given disclose a range of situations in such relief in which such relief has been granted. In some cases, such as the Canadian case of Lee and Rao, the injunction was based on an express contractual promise not to arbitrate, or not to arbitrate until a particular issue had been first determined by the court. There's nothing heterodox about the issue of an injunction in equity's auxiliary jurisdiction in this context, assuming, of course, that the jurisdiction has not been impliedly excluded by arbitration legislation adopting the model law. Therein lies the real significance of the recent decision by the Chief Justice of Western Australia. Other cases in which anti-arbitration injunctions have been granted rest not on an express contractual right not to be subjected to arbitration, such as Lee and Rao, perhaps the paradigm case for the grant of such relief, but rather on the demonstrated absence or loss through, for example, waiver or estoppel of any contractual basis which would underpin and justify arbitral proceedings, including where, for example, the applicant for injunctive relief has been held not to be a party to the arbitration agreement. Injunctions issued in this context take one outside of equity's auxiliary jurisdiction and cause one to ask what is the equity or equitable interest that justifies injunctive relief. It is somewhat strained and artificial to speak of a, quote, right, unquote, not to be subjected to arbitration. An applicant for injunctive relief in this circumstance has no contractual or other legal right not to be subjected to arbitration. It's just a fact that they're not party to the agreement or the agreement has ceased to have effect. It may simply be that courts characterise the continuation of arbitration in the face of a finding that the dispute falls outside the scope of the arbitration clause or is not arbitrable, or that for whatever reason the arbitration agreement is not operative, as instances of vexation or oppression in the sense in which that expression has come to be understood in the anti-suit injunction jurisprudence. One of the vices which anti-suit injunctions, as opposed to anti-arbitration injunctions, are often deployed to address is that of overlapping, if not entirely parallel, sets of proceedings occurring concurrently. In this context, one cannot help but observe that Article 8 of the model law may be seen as positively encouraging a multiplicity of jurisdictional proceedings. Thus, whilst Article 8.1 provides in familiar terms that a court before which an action is brought in a matter which is subject to an arbitration agreement shall, if the party so requests, refer the parties to arbitration unless it finds that the agreement is null and void, inoperative or incapable of being performed, Article 8.2 provides that where an action referred to in paragraph 1 has been brought, that's to say, in court proceedings, arbitral proceedings may nevertheless be commenced or continued, and an award may be made while the issue is pending before the court. Article 8.2 thus expressly contemplates and possibly encourages a circumstance where concurrent arbitral proceedings may be commenced while there is litigation on foot, but where the court in which such litigation has been commenced has not yet ruled on the referral application. Both the court and the tribunal may thus be simultaneously engaged in a consideration of questions going to the very existence or continuing operation of the arbitration agreement. That lends itself to a situation in which vexation and oppression, at least as understood by common law courts, might be thought to arise. And it's in this area that the tension between competens, that's to say the arbitral tribunal's ability to rule on its own jurisdiction, and the assertion by Anglo-American courts and other common law courts of an entitlement, perhaps not unqualified, to rule on the existence or continuing efficacy of the arbitration agreement, and depending on that conclusion, to act accordingly by acceding to injunctive relief, is at its most acute. In some cases, going beyond questions of what I will call arbitral jurisdiction, the continuation of arbitration may be seen as an interference with the processes of a court. The Ministry of Finance case in the English Court of Appeal, that's to say where there was pending a challenge to the consent award, may be seen as an example of that, as can the Kraft case, where the injunction was justified both on the basis, on that basis and on the basis of what was considered to be vexatious and oppressive duplicative litigation. Injunctions granted on this basis will tend to be of an interim or temporary nature and subsist only pending the resolution of the duplicative issues in court proceedings, a bit like the Heifert case as well. But such resolution may in turn generate complex questions in relation to issue estoppel. Now, the three bases identified for the grant of anti-arbitration injunctions, namely breach of a contractual promise or right not to be subjected to arbitration, secondly, vexation and oppression, and thirdly, the protection of the court's processes once set in motion, closely resemble and mirror the bases for the grant of anti-suit injunctions articulated in CSR and Cigna in the High Court. But it should be observed that whichever body, court or tribunal, rules on the existence or continuing operative effect of an arbitration agreement, extremely complicated choice of law questions potentially arise. Here, subject to one possible qualification, one should have resort to the proper law of the arbitration agreement, which of course may not be the same as the proper law of the commercial agreement in which the arbitration agreement sits. And it may not be at all straightforward or easy to identify what that proper law is. One only has to embark on reading the decision of the UK Supreme Court last Friday in the Insat litigation to appreciate the potential complexity of that exercise. Now, let me, at this point, just pause to note the theoretical arguments for and against anti-arbitrations. In an excellent paper entitled The Use and Abuse of Anti-Arbitration Injunctions, A Way Forward for Singapore, Nicholas Poon, that was written I think in 2013, Nicholas Poon wrote that there is mounting acceptance for the idea that early determination of issues concerning the jurisdiction of the arbitral tribunal is in the best interest of the parties and the arbitral process. This must be right, he says. A party that does not have an obligation to arbitrate the particular dispute should have its rights not to be subject to arbitration protected by way of an anti-arbitration injunction. A party facing a multifaceted dispute covering both arbitrable and non-arbitrable issues should also be allowed the opportunity of having the non-arbitral issues resolved prior to the conclusion of the arbitration by seeking an interim anti-arbitration injunction. Why, it might be asked, should a party which why, it might be asked, should a party which asserts that is not bound by an operative or enforceable arbitration agreement have to run that argument first before arbitrators who are not necessarily lawyers or lawyers familiar with the proper law of the arbitration agreement, and have to wait until the enforcement stage before it can re-agitate such an argument before a court, or to appeal to the court of the seat of the arbitration, to which ex hypothesi it has never agreed, or it contends is no longer bound. This question might be thought to be particularly acute in light of the UK Supreme Court's earlier decision in Dalla and Ministry of Religious Affairs of the Government of Pakistan, in which it was held that the arbitral tribunal's decision as to the existence of its own jurisdiction could not bind a party who had not submitted the question of arbitrability to that tribunal. No less an authority than Lord Collins of Mapesbury, long-time General Editor of Dicey and Morris, said that the arbitral tribunal did not have the exclusive power to determine its own jurisdiction, nor does it follow that the court of the seat may not determine whether the tribunal has jurisdiction before the tribunal has ruled on it. And so much is also, I think, implicit in Article 8 of the Model Law and Section 7.2 of the International Arbitration Act. The combination of Dalla and the High Court of Australia's extremely broad view of through and under in Hancock prospecting means, as it seems to me, that there are bound to be cases where corporations or indeed individuals not party to an arbitration agreement nonetheless will either seek to initiate or potentially be dragged into arbitrations. The anti-arbitration injunction may be a powerful remedy in this context. On the other hand, there is a strong case that can be made against the issue of anti-arbitration injunctions at all, a position which appears, as I've said, to have recently been confirmed in India. With perhaps predictably loaded pro-arbitration language, Professor Gary Bourne has written that typically anti-arbitration injunctions are purportedly justified on the grounds that there's no valid arbitration agreement and one party is therefore entitled to an order preventing an illegitimate process going forward. He says in many cases anti-arbitration injunctions are part of a deliberately obstructionist tactics typically pursued in sympathetic local courts aimed at disrupting the parties' agreed arbitral mechanism. Of course, the phrase agreed arbitral mechanism wholly and utterly begs the question. Bourne has suggested that the issuance of an anti-arbitration injunction against an arbitration subject to the New York Convention is generally contrary to the basic legal framework for international arbitration established by the Convention. He puts this not on competens grounds alone, but he says, quote, "It is the multilateral international legal framework under the Convention in which all contracting states have mutual obligations to recognise and enforce arbitration agreements that argues cogently against the issue of anti-arbitration injunctions enjoining international arbitral proceedings and award enforcement, even though such injunctions might well be permissible and sensible in domestic matters." That argument, which I remind you had been rejected at least by the American Law Institute, is not dissimilar to that which was favoured by the European Court of Justice in the West Tankers litigation in relation to anti-suit injunctions, and that decision highlighted the incompatibility of the issue of anti-suit injunctions within Europe with the overall framework for the allocation of jurisdiction and enforcement of judgments within Europe. It's an analogous argument that the framework of the New York Convention shouldn't be disturbed by anti-arbitration injunctions issued by domestic courts. Now, on its face, Article 5 of the Model Law, which corresponds to Section 5 of our Domestic Arbitration Acts, and which provides, in matters governed by this law, no court shall intervene except where so provided in this law, might be thought to suggest that unless expressly provided for, which it's not, intervention by anti-arbitration injunction is not permissible. That argument was rejected in the UK in the AES Ust Kamenogorsk litigation in the Supreme Court, although its rejection turned on a nuanced interpretation of Section 1C of the 1996 Arbitration Act, where Lord Mance said that whereas the model law uses the expression shall not intervene, the Arbitration Act uses the expression should not intervene, which he said meant that the court could intervene but should not do so regularly or commonly. In Australia, of course, that argument is not available because by Section 16.1 the International Arbitration Act and subject to Part 3 the model law has the force of law in Australia. However, because of its particular operation, the details of which I won't go into, the prescription on intervention by Article 5 of the model law, to the extent it might otherwise be contended to be a prohibition on the issue of an anti-arbitration injunction, has no application where the arbitration is occurring or is due to occur outside Australia. That would be my interpretation of the issue. And additionally, the model law has been held to have no application in circumstances where the anti-arbitration injunction is sought by a non-party to the arbitration. That was the unusual circumstance that came before the court, the Federal Court of Malaysia, in the Jayasuriya case. In the Sabag case, the 2019 English Court of Appeal decision, Lord Justice David Richards expressly rejected the argument that the UK Arbitration Act and the international instruments on which it was based impliedly prohibited the grant of anti-arbitration injunctions where it was said that the pursuit of the arbitration was vexatious or oppressive. Now, the way these theoretical arguments have tended to be resolved is that most courts, perhaps unsurprisingly, have continued to assert their ability to grant injunctions in this context, but have generally said that they should only be issued in exceptional cases. But is or should that be the case? Related to this is the issue as to whether, as is the case with anti-suit injunctions, the frequently mentioned but often elusive concept of comity has any role to play in the issue of anti-arbitration injunctions. So we know that in the anti-suit discourse, an anti-suit injunction, although directed in personam to the moving party in the foreign proceedings, is said for that reason not to be an interference with the foreign court. In substance, the effect of the injunction, if observed, would be to bring proceedings in a foreign court to an end, and hence the concern about comity. But why should comity have any role to play in the grant of an anti-arbitration injunction where the proceedings being restrained are in truth nothing more than the creature of a private contract between the parties to the arbitration? An arbitral tribunal, after all, and unlike a court, is not an emanation of the state whose sovereignty may be perceived to be infringed by an anti-suit injunction, albeit indirectly and in substance rather than in form. It could be argued that an anti-arbitration injunction does have the potential to infringe comity, as it may usurp the role of the courts of the seat of the arbitration, which are generally regarded as having the paramount role to play in the overall supervision of the arbitral process. The significance of the curial jurisdiction of the Court of the Seat is well known. Unlike an anti-suit injunction, however, where the jurisdiction of the foreign court will generally already have been invoked, it is far less likely that an anti-arbitration injunction would cut across any litigation in the courts of the seat of the arbitration. It is difficult to see how any considerations of comity, even indirectly, might be engaged in these circumstances, just as the claims of comity are surely diminished, if not wholly absent, in a case where an anti-suit injunction is granted, restraining the institution as opposed to the continuation of proceedings in a foreign court. Now, this leads me to consider whether any particular restraint should be exercised in the grant of an anti-arbitration injunction more generally in circumstances where a case is otherwise made out for such relief. In Kraft, Justice O'Callaghan in the Federal Court said that there was no different prism to be looked at or any extra caution required to be exercised in deciding whether to grant an anti-arbitration injunction. He said the question is to be addressed as whether the injunction should go consistently with the principles applicable by analogy from CSR and Cigna. But he said no part of the exercise of the court's discretion on an application for an anti-arbitration injunction involves the court asking itself or needing to determine whether the relief claimed is exceptional. A more or less robust approach was articulated by Lord Justice David Richards in Sabar in the English Court of Appeal. He acknowledged that an anti-arbitration injunction involves an interference with, he said, a different principle, namely the fundamental principle of international arbitration the courts should uphold and therefore not interfere with arbitration agreements. He said, where it is clear that the dispute is within the terms of a valid arbitration agreement, then the court should not interfere. When the converse is true, either because there's common ground between the parties or because of a previous determination, the court may grant an anti-arbitration injunction, but only where the circumstances of the case require it, save perhaps in the case of exclusive jurisdiction agreements. The grant of an anti-arbitration injunction remains, he said, an exceptional step. Now, by way of conclusion, I'll say this. Towards the end of his article, The Use and Abuse of Anti-Arbitration Injunctions, A Way Forward for Singapore, Nicholas Pern states, quote, that a tension between the courts and arbitral tribunals is not healthy and should be avoided as far as practicable. I'm not sure I entirely agree with that suggestion for reasons I'll explain, nor with respect do I fully agree with Professor Garnett's suggestion in the context of an English decision called Golden Ocean that, quote, an English court owes a duty to both the foreign arbitral tribunal and the supervising court not to interfere in the absence of exceptional circumstances, unquote. A measure of deference may be, but surely not a duty. Professor Garnett expresses it as, I think Professor Bourne does, as a duty arising from the international scheme. I find that argument difficult to accept, at least to the extent of formulating or characterising it as a duty. Returning to Mr. Pern's observation, a tension between courts and arbitral tribunals may, in my opinion, be extremely healthy, so long as it's kept in check and courts only intervene in a principled and measured way. Judicial intervention, or the possibility thereof, may serve as a valuable control mechanism to ensure that the arbitration of commercial dispute is authorised, justified and conducted fairly. The familiar criteria for intervention, largely borrowed from anti-suit jurisprudence, and which have been identified in English decisions such as Claxton in the draft US restatement and in the decision of Kraft, make it plain that intervention will not be an everyday remedy. TCL air conditioner in the High Court reminds us all of the fundamentally contractual nature of arbitration. In most cases, there will be no dispute as to the binding nature and continuing operation and efficacy of the arbitration agreement. But where there is a dispute, if a court has personal jurisdiction to rule on that question, I say has personal jurisdiction over the moving party in the arbitration, and does so an injunction restraining the commencement or continuation of an arbitration inconsistent with the court's conclusion as to the contractual underpinnings or absence thereof seems to me to be entirely orthodox, as does the restraint of vexatious or oppressive or unconscionable conduct in the conduct of the arbitration. The privatisation of commercial justice, which is what arbitration is here to stay, but it was never intended to amount to a wholesale surrender of the dispute resolution process, wholly divorced from the ultimate and transparent oversight of the courts. Whether what I have described in this lecture as the rise of the anti-arbitration injunction reflects something of a recalibration in the enthusiasm for and judicial confidence in arbitration and arbitrators is part of a larger topic, which is for another day, and hopefully one that might be discussed in person in another part of the world to which we can all travel. Thank you very much.
To Justice Bell for his address. His very thoughtful theoretical and practical analysis of the considerations affecting the availability and use of the anti-suit injunction is very timely. His Honour considered the important distinction between the anti-suit and anti-arbitration injunction and the tensions between the latter and the broad trend of judicial support for arbitration. In doing so, His Honour referred to the tempering of the primacy of freedom of contract by doctrines of unconscionability, expansion of estoppel and the emergence of good faith, and the growth of the anti-suit injunction internationally as a recognised remedy, anti-arbitration injunction internationally as a remedy. Your Honour also had detailed regard to the wide-ranging legal bases upon which arbitration injunctions might be sought, including express contractual promises not to arbitrate, the demonstrated absence of a contractual basis to underpin arbitral proceedings, and not entirely parallel sets of proceedings occurring concurrently, and indeed applications by a non-party to the arbitration contract. Your Honour also considered limitations to the power on the award of an injunction. Your Honour has also referred to functional equivalence of the anti-arbitration injunction and the interplay between the courts and the appointed panel on jurisdiction, including to determine the existence of an arbitration agreement. Your Honour has referred to international judicial attention paid to the issuing of an anti-arbitration injunction by a court not of a seat of the arbitration in recent decisions. Your Honour has examined the theoretical arguments for and against anti-arbitration injunctions, including the countervailing argument by reference to Professor Gary Bourne's suggestion that the issuance of an anti-arbitration injunction against an arbitration subject to the New York Convention is generally contrary to the basic legal framework for international arbitration established by the New York Convention. Your Honour has also considered the importance of comity and restraint in the granting of anti-arbitration injunctions. Your Honour concluded that the possibility of a judicial intervention may serve as a valuable control mechanism to ensure that arbitration of a commercial dispute is authorised, justified and conducted fairly, and this is in circumstances where, as Your Honour observed, that privatisation of commercial justice was not intended to be a wholesale surrender of the dispute resolution process, wholly divorced from the transparent oversight of the courts. Your Honour's reasoned and insightful paper will serve as a starting point for further academic analysis, including, as Your Honour has said, in respect of the enthusiasm for and judicial confidence in arbitration. It will also serve as an important guide for practitioners in both the drafting of arbitration clause by reference to the parties' intended consequences and the availability and application of the remedy itself. Would you please join me in thanking again Justice Bell for his presentation. Thank you. That concludes this evening's presentation. Thank you very much for your attendance.